procedures.
No, where is the adoption?
The adoption.
They have not adopted CCA rules.
Your Lordships,
They have not adopted CCA rules.
Your Lordship, it says, no, for which no provision is made in these rules shall be the same as are for the time being applicable to other officers of the Government of India of corresponding status.
What is that? What is meant by that?
Your Lordship, so whatever is not provided for in these rules, they go by the CCS rules. That is the procedure he has explained, Your Lordships. And it is not that the entire CCS rules are adopted, it is just what is not provided for here, they take from there, Your Lordships. In matters of in matters of LTC or in these matters, pension, for that they go to the central government rules, Your Lordships.
Charge was framed under which rule?
29D, Your Lordships.
29? Charges framed. Where is the appeal provision?
Appeal
rule 28 is there.
Appeal is, Your Lordship, rule 28.
How can you resort now, jump to the CCA rules?
Your Lordship,
when you have everything is in these rules.
Your Lordship, because the
insofar as initiation of inquiry against CRPF,
Your Lordship, Rule 29 is the revision under which this order has been passed. Your Lordship, D, the Director General or Special Director General or the Additional Director General heading the zone or the Inspector General or the Deputy Inspector General may call for the records of award of any punishment and confirm, enhance, modify or annul the same, or make or direct further investigation to be made before passing such orders, provided that in case in which it is proposed to enhance the punishment, the accused shall be given an opportunity to show cause either orally or in writing as to why his punishment should not be enhanced. Now in this case, Your Lordships, whatever happened, if I can recall the facts, the DIG had enhanced the punishment to dismissal from service. The matter went before the Inspector General. He set aside that order, reinstated the petitioner in service and ordered that fresh inquiry be made. That is what has happened. De novo, he ordered.
Where is the provision for fresh inquiry?
That they have taken from the CCS rules.
That can't be taken.
That they have taken under umbrage of Rule 102.
No.
That is what they have done, Your Lordships. That is what they have done. I will not say. They have taken umbrage of Rule 102 and gone into CCS rules because they say that there was no procedure, detailed procedures were not laid down in these CRPF rules. Therefore, they have taken the detailed
Which authority?
Ji?
Which authority has taken invoke Rule 102 read with CCA rule?
Your Lordship, that Inspector General. That is the Inspector General, Your Lordship.
Huh?
Inspector General.
On what date?
On date of the order. 12/9/2000, Your Lordships.
12/9/2000.
The Commandant 133 BN CRPF will initiate a
That is without authority of law. CCA rules are not applicable.
Your Lordship, the wording is what he should have said was that should from the initial stage he should have the word he has used, Your Lordship, but seeing the gravity of the misdemeanor.
All right, but there is no provision.
Your Lordships, even that aside, Your Lordship.
Mr. Counsel, you can't have a piecemeal. One piecemeal I will take from Rules 1955, from the date of initiation of inquiry till revision. While passing revision, you switch over to CCA rule. How is it permissible?
Your Lordships, even in the CRPF rules, if the word de novo had not been there, he could have said He could have said.
No, where is the power of remanding the matter under Rule 29?
29D is a further investigation to be made.
Huh? Further investigation you can do, but no question of de novo.
Huh? The charges are the same, Your Lordship.
Huh?
The charges are the same. He has not changed the charges.
No, that's all right. But you are permitted to only reinvestigate.
Essentially, Your Lordship, that is. Yeah. Your Lordship, because in the earlier proceedings, there had been some procedural mistake. Therefore, he set aside the order of the DIG. Removal from service order was set aside. The petitioner was reinstated in service, and he said, "You do the inquiry afresh."
The later part is not. Later part is without authority of law.
Your Lordships, then the inquiry will have to be done.
Huh?
Your Lordships may order inquiry to be done from that stage.
No, but do whatever you want, limited to Rule 29 of CRPF rules.
Your Lordships, then
I will only quash the later part and leave it. You do you invoke 29 and reinvestigate or do whatever you want, but it should be within the frame of Rule 29. Why are you behind him? 1998 allegation.
Your Lordship, then Your Lordships, if I may pray, Your Lordship, then from that stage where he found that some procedural error had happened.
All right, sir. After these many decades, you want to reinvestigate?
Not reinvestigate. From the stage of providing the copy of the inquiry report, from there
No,
they can proceed.
that is not the issue. From the revision, in the revision, you have already set aside the order, and now you are ordered for de novo inquiry.
Your Lordship.
That is 12 years back.
Your Lordship, then.
What is the date of retirement?
He is 53 years of age, my lord.
Huh?
Presently, he is 53 years of
He is
age.
still in service.
He is 7 years left of in service.
What is the charge?
The allegation, my lord, the memo of charge, if your lordship will kindly come to the annexure 11 of my supplementary affidavit, my lord.
What is the charge I am asking you?
My lord, the charge is that it is suspected that in a suitcase certain amount of ganja was recovered, and it is suspected that the petitioner was carrying that.
All right, let them have a reinvestigate.
And my lord,
He was carrying narcotics,
this matter was.
A review was suo motu or you have filed?
No, review they made. Initially I was awarded with punishment of withholding of two increments.
Sir, you have filed review or suo motu they have taken?
They have suo motu review.
Suo motu review.
My lord, the entire fact has been recorded by your lordships in lordships order dated 27th of July 2022.
Suo motu review was undertaken by the official respondent while passing a order of removal from service on 6/11/1999.
No, Your Lordship. Your Lordship, it's not, the facts are not like that. He was the DIG in appeal and has the punishment to removal from service. And by suo motu revision, the order.
No, what happened on 6/11/99?
6/11/99. 6/11/99.
Annexure A9, supplementary
Annex.
affidavit.
Annex A9. Six 11/99.
It was reviewed by the DIG. It was the review by the DIG.
That's what I have dictated.
Yes, that's
Who
removal.
is assisting you? You don't have assisting counsel.
Mr. Manoj, Your Lordship, that is removal from service, Your Lordship.
That's what I have dictated.
I know,
Review.
I'm sorry.
Suo moto review was taken.
Yes. Oh, I'm sorry, Your Lordship.
Mr. Assisting counsel, please sit to next him and assist him.
I'm sorry, Your Lordship. I thought it was order dated 12/9.
Against the order of the removal from service, an appeal was preferred and it was allowed in favor of the petitioner on 12/9/2000, by which order of removal was set aside. While doing so, de novo inquiry has been ordered. First up, next up. In the result, once again charge memo was issued on 20th January 2001. Petitioner submitted his reply. And other formalities have been completed till imposition of penalty of removal from service on 10/11/2001. What happened on 31/8/2002? No, appeal.
The
Appeal was filed and further revision was filed and revision was rejected on 9/12/2002. Further, he had submitted representation and it was also rejected on 24/7/2003. In this backdrop, the petitioner has presented this petition. Please stop. Next, Learned Counsel for the petitioner submitted that question of ordering de novo inquiry wide order dated 12/9/2000 is not permissible under Rule 29 of Rule 29 of Rules 1955. Full stop. At the best, competent authority who has passed the order on 12/9/2000 can order reinvestigation. Full stop. Per contra, and counsels for the respondents resisted the aforesaid contention and submitted that de novo inquiry is permissible in the light of Rule 102 of Rules 1955, read with Central Civil Service within bracket CCA Rules 1965. In particularly Rule 29D.
yes,
In
full
29, small d or big D?
small d.
Small d. Full stop. Heard the learned counsels for the respective parties. The petitioner was charge sheeted. Petitioner was subjected to inquiry in framing article of charges on 2/2/1998. It was concluded in imposition of penalty of withholding of 2 increment with the cumulative effect on 22/2/1999. Thereafter, the official respondents were suo moto taken up the matter and proceeded to enhance the penalty, the aforesaid penalty, to that of removal on 6/11/1999. Full stop. Feeling aggrieved and dissatisfied with the order of removal, petitioner preferred appeal and it was allowed on 12/9/2000. Full stop. removal order was set aside by the appellate authority, and further de novo inquiry has been ordered in the very same order. Thereafter, once again petitioner was subjected to charge memo till imposition of penalty of removal from service, and further rejection of revision and representation on 9/12/2002 and 24/7/2003. Short question for consideration in the present petition is whether appellate authority, while setting aside the order of removal from service on 12/9/2000, is empowered to order for de novo inquiry under Rule 29 of Rules 1955 or not. Further, is he empowered to invoke Rule 29 within bracket small d of Rules 1965 read with Rule 102 of Rules 1955 or not? Full stop. It is to be noted that petitioner was subjected to disciplinary proceedings in framing article of charges under Rule 27 of Rules 1955. Full stop. Once the disciplinary proceedings have been lodged against the petitioner under a particular rule, in the present case CRPF rules, 1955, ultimately the conclusion must be only under Rules 1955. Full stop. Impugned order, insofar as ordering a de novo inquiry dated 12/9/2000, does not reveal under which provision of law. Full stop. In the present case, the concerned respondent trying to interpret that Rule 27 within bracket D of Rules 1965 has been invoked for the purpose of ordering a de novo inquiry, for the reasons that Rule 29 of Rules 1955 do not permit for ordering de novo inquiry other than reinvestigation. Full stop. Rule 102 reads as under. Full stop. The aforesaid rule could be invoked if the CRPF employees are not governed by disciplinary rules in entirety. On the other hand, Rule 27 of Rules 1955 provides for procedure for award of punishment. Further, Rule 28 provides for appeal, and Rule 29 for revision. Once the official respondent have entertained revision under Rule 29 of Rules 1955, in that event, the official respondent cannot take shelter under Rule 102 and resort and proceed to say that Rule 29 within bracket small d of CCA Rules 1965 would come into the aid of ordering de novo inquiry on 12/9/2000. Full stop. In other words, official respondent cannot choose use the pick and method principle in respect of initiation of inquiry and completion of inquiry Full stop. In fact, initiation of inquiry against the petitioner and till filing of a revision is under Rule 1955, whereas to sustain the word of de novo inquiry in the order dated 12/9/2000, the official respondent cannot take shelter under Rule 102 read with Rule 29 within bracket D of CCA Rules 1965. In the light of these facts and circumstances, insofar as ordering de novo inquiry under order dated 12/9/2000 till rejection of revision dated 9/12/2002 read with rejection of representation dated 24/7/2003 stands vitiated. Full stop. However, reserving liberty to the revisional authority to pass issue corrigendum order in respect of implementation of Rule 29 of Rules 1955. Such a corrigendum order shall be passed within a period of 3 months from the date of receipt of this order. Full stop. Next paragraph. In the meanwhile, the disciplinary authority is hereby directed to take a decision as to whether the petitioner be placed under suspension or he shall be taken back to duty and further passing of a corrigendum. Full stop. Assuming that in the corrigendum the competent authority takes a decision that the matter is required to be reinvestigated, in such circumstances necessary proceedings shall be completed within a period of 6 months from the date of receipt of this order. Full stop. Next paragraph. The disciplinary authority is hereby directed to take note of Apex Court decision in the case of MDECL versus B. Karunakaran reported in so and so, read with Coal India so and so, para 42, 46 to 50. Further, a latest decision of the Apex Court decision, Apex Court insofar as reiterating the principle laid down in the MDECL case reported in so and so be taken into consideration for the purpose of regulating the intervening period from the date of removal from service till passing of a fresh order in a departmental inquiry, if any. Full stop. The aforesaid period is required to be regulated in accordance with law after giving an opportunity of show cause notice to the petitioner. The above exercise shall be completed within a period of 2 months from the date of completion of reinvestigation / departmental inquiry, if any. Full stop. Next paragraph. Accordingly, so and so annexure stands set aside